Shashi Sarve Santu, Nirav Modi Sarve Santu, Lalit Modi Sarve Santu, Vijay Mallya Sarve Santu, Mehul Bhai Sarve Santu.
Honourable Deputy Speaker, thank you very much for the opportunity to address the House on a topic that has really been of great concern to all of us here, particularly in recent years. I think all of us share the nation's concern about this jhoot, loot, scoot culture that has become dominant and that have seen so many economic offenders fleeing the country and refusing to come back to face justice. Now, you know, Mr. Chairman, we had high expectations of this bill. I note that earlier this year it was none other than our esteemed Prime Minister who had raised a word of warning to financial and regulatory authorities on the increasing number of financial fraud and fugitive economic offenders. And to quote our PM, he said, "I want to make an appeal to those who have been entrusted with the job of framing rules and policies and maintaining ethics to do their job diligently and with dedication." These are the Prime Minister's words. Now, these are promising words, and we in the Congress Party had hoped that perhaps for at least one time in these 4 years, the present ruling dispensation would actually come through on a commitment. But as usual, Honourable Deputy Speaker, as has been the legacy of this government, there remains a significant gap between the rhetoric of its leadership and the reality that is suggested by the nature of the bill before us today. In the last few years, we've seen a string of businessmen flee the country after allegedly defrauding numerous creditors, especially public sector banks, under the watch of the very men who promised to be the watchmen, the chowkidars of India today. The magnitude of the crisis is seen by a response of the Ministry of External Affairs in the Lok Sabha, which has itself admitted that in March this year, India had the woeful record of having 31 fugitive economic offenders who had collectively robbed the honest taxpayer over 40,000 crores. That's the figure given by the MEA to this House. Now, Honourable Deputy Speaker, to give that figure, 40,000 crores, some perspective, that is also nearly the same amount that this government allocated on paper to the Manrega scheme, the Mahatma Gandhi National Rural Employment Guarantee Program, and they took credit saying this is the highest, record highest ever allocation in 2017-18 for this scheme. They didn't actually give all the money. That's the amount of money that seems to be on the books of our fugitive economic offenders. While the men and women of the country dependent on their daily wages are struggling with delayed payments because the government apparently doesn't have enough money to give the states to pay our Manrega workers, our white-collar economic offenders have got away from this country with impunity. And the fact is that given these abject circumstances, I must say that we had hoped for effective and workable legislation from this government to tackle this pressing issue with conviction. But is it already too little too late? As my friend Sri Premachandran has already pointed out, the biggest fugitives have already left the country. The government has failed to extradite them, and I'm going to come back to that. Vijay Mallya escaped 2 years ago. Nirav Modi fled in January 2018 after gleefully taking a photograph in Davos with our Prime Minister. Yes. It's interesting to hear the BJP speaker talk about Congress associations. The pictures are of apparently our own Prime Minister and his company. Jatin Mehta of Winsome Diamonds left for St. Kitts in 2016, and Lalit Modi benefited from a no-objection intervention by our own Minister of External Affairs in 2015, which was a big issue in this House just 3 years ago. They are all living in luxury abroad. हम आपकी सरकार से बस एक ही चीज पूछना चाहते हैं, किसका साथ, किसका विकास? But anyway, before analyzing this bill, we must ask ourselves, what is the situation that necessitates the need to enact a particular kind of legislation? Now, normally there is a flaw in certain statutes or provisions that is being exploited by individuals to escape the law, then undoubtedly a legislative remedy is required. I'm sorry to say that there is absolutely no indication in this bill of a remedy or even a slightly progressive step to address the larger malaise in our regulatory and financial institutions. Instead, we have a poorly crafted draft, which it seems little thought has been given to, and the entire exercise, I'm sorry to say, reeks of tokenism and political doublespeak. And I will explain, Mr. Chairman, why, because my problems with this bill are practical, legal, and constitutional. Now, the statement of objects and reasons of the bill states that the existing civil and criminal provisions of the law are inadequate to deal with the problem of economic offenders fleeing our jurisdiction. So they're saying that when you have somebody absconding with the proceeds of crime, there are no laws to deal with it. That's absurd. There are very much existing laws. We have our Criminal Procedure Code, the CRPC. The question before us is to ask whether the proposed legislation is better than the present legal regime. What is the problem you are fixing? What are your improvements? I mean, the previous speaker at length went on about NPAs. First of all, the government's own figures confirm that the quantum of non-performing assets in the public sector banks in our country has more than doubled since they came to power. So they are the ones who bear the bulk of the burden of the NPAs. But more significantly, is the BJP seriously arguing that the bulk of these NPAs are due only to fugitive economic offenders? NPA issue is a much bigger problem. We're very happy to have a debate on that in this House, Mr. Chairman. But the fact still remains that this is clearly not the problem that they can fix in this way. Now to the specific objections. First, under Section 82 of our existing Criminal Procedure Code, if any court has reason to believe that a person is evading a warrant issued by it, then it can require him to appear before the court within 30 days. And if he fails to do so, it's already in our law today, any property of the concerned person can be attached under Section 83. That's our present law. So what are they fixing? Under Section 10 of the bill, however, once an application has been filed to declare a person as a fugitive economic offender, this bill gives him 6 weeks to appear. And an additional period of 1 week may be given if his counsel appears on his behalf. So in fact, this bill actually gives a fugitive economic absconder and offender more time than the existing Criminal Procedure Code. Instead of 30 days, he's getting 7 weeks, 42 days. Now, please explain the logic behind this generosity in the bill. Now, under the bill, only if a person has a warrant issued against him for a scheduled offence involving 100 crores or more will he come under the ambit of this law. Now, this is a very interesting number. Where does it come from? With this threshold, it means somebody can swindle 80 crores, 90 crores, even 99.99 crores, and he would not attract any of the provisions of this law. Where on earth did our government decide that 100 crores is the only level at which we should take these people seriously? Under the Prevention of Money Laundering Act, which has already been referred to in this House, offences involving 1 crore or more are covered. 1 crore or more. It is important that this 100 crore threshold should be removed so as to ensure that all types of white-collar absconders are brought under the ambit of the law. See, I want to agree, Mr. Deputy Chairman, Deputy Speaker, we need a strong law to deal with fugitives and absconders. But at the same time, we have a constitutional ethos to preserve. We have a legal culture to preserve. We are a democracy, not some sort of tin pot dictatorship. We must have sufficient safeguards built into the law to prevent it from being used as a tool of harassment by the government. Now, if you look under Section 14A of the bill, once a person is declared a fugitive economic offender, then any court or tribunal in India may disallow such a person from putting forward or defending any civil claims in court. Any. Now, any civil claims means what? You are effectively extinguishing a human being's right, an Indian citizen's right, to any civil remedy. For instance, if a person is a fugitive, but at the same time he's part of a property dispute or he's part of a divorce proceeding, under the provision he can't defend himself. He cannot take any action in any court of law. This is a bizarre logic. The provision can prevent him from exercising his rights as an Indian citizen. In such cases, even those rights unconnected to the economic offence that he has committed. The Supreme Court has clearly held that the right to access courts is an inalienable right, which is, and I'm quoting the Supreme Court judgment, so basic and inalienable that no system of governance can possibly ignore its significance, leave alone afford to deny the same to its citizens, unquote. That means the right to access justice, which has been challenged by the previous speaker, flowing from Article 21 and Article 14 of the Constitution, requires the ability to go to a court and ask the court to defend your rights, or at least to hear your side. Extinguishing such a right, even in the case of a fugitive, will be found by any half-educated judge to be a violation of the Constitution of India. Why are we bringing forward such an obviously unconstitutional provision that flies in the face of Supreme Court judgments? The government really owes us an explanation on this. Section 14B goes even further, because the right of companies to approach civil courts is also extinguished if the person filing on behalf of a company is a manager, a director, or a shareholder, and he happens to be a fugitive economic offender. So the government will no doubt argue, they haven't come up with this yet, but they may argue this will force companies to get rid of such people from their companies. But the fact is, majority shareholders can't be changed overnight. My good friend Piyush Goyal knows that very well. They're the ones who bring capital to the company. So the provision will suddenly mean that other shareholders, minority shareholders perhaps, will be punished and their investments affected for no fault of their own. The Supreme Court in a different recent judgment had said, and I quote the Supreme Court again, when something is done which is excessive and disproportionate, such legislation would be manifestly arbitrary. This provision is manifestly arbitrary because it affects the rights of people who are not offenders, and it will clearly not survive a constitutional test. And I'm asking again the government, why do you produce an unconstitutional law that you know has no chance of going past the existing judgments of the Supreme Court that I have cited? Now, it's purely for optics, purely for optics. We'll come back to that. Now, once a person is declared a fugitive economic offender, we all heard this already, his properties are confiscated and vested with the central government. Now, under this bill, the centre, of course, can, as Mr. Mahtab already asked, try and recover the money by selling off the property they've confiscated. But remember that the declaration of a person as a fugitive economic offender is not a conviction. It is not a result of a criminal trial. It is a declaration based on prima facie material. Sale of property, unlike the confiscation of property, cannot be undone, and therefore it can only be resorted to once a person has already been convicted. Now, the government may say, well, under the Money Laundering Act, we can dispose of property vested with us. But even that only happens under the Money Laundering Act after a trial. Here there is no trial. So now the government wants to make itself the trial court as well and take on powers that in the history of India no government has had without going before a judge. Now, I think as legislators, Mr. Deputy Chairman, we have the responsibility to ensure that any bill we pass is legally sound and fair and reasonable. The property of a fugitive economic offender may be attached by the court. There may be third parties who have leasehold rights or mortgage rights on such property. And of course, the bill does provide that these properties should not then be confiscated. But then those individuals who have no connection with the crime committed by the accused, they have the obligation to prove that they actually have a legitimate interest in the property without knowing that the property is the proceeds of a criminal act. How is somebody supposed to know that? After all, they will act in good faith with their business partners, with their company officials, their shareholders. It seems to me that you're now using this bill to reverse the onus, and instead of the prosecution having the responsibility to show that any third party has reasonable grounds to believe that the property arose out of criminal activity, instead you're taking away his right to rebut such charges, and you're saying that he no longer has any rights. This section too would need to be amended, because you cannot punish the innocent and deprive them of their legal rights. This would set a very dangerous precedent in other matters in our country. Now, the bill also suffers from a major lacuna, because, of course, the whole question of properties which are not part of criminal proceeds, over which third parties have interest but are yet attached, has not been addressed in the bill, and that lacuna will need to be dealt with. Now, one more thing is the power of notification that the government has taken upon itself. You see, it says that the offences which need to be attracted to show a person as a fugitive are listed in the schedule, but the government can make changes to the schedule by notification. Now, this means the power can be misused by the government whenever it likes. If there is a person, for example, who is close to the ruling party, an allegation we have heard from the other side, then the government can quite simply change the schedule and decide that that offence does not attract this bill. Why don't we have a much more sensible precaution and say that if any changes need to be made to the schedule, it must be through the sanction of Parliament. The government has to explain to Parliament the reasons and purpose of the change, rather than taking on the power to itself to change the schedule arbitrarily. These notifications can be placed before the House. You know, we have a problem, so you are a long-term legislator, you know what I'm talking about. We have very weak scrutiny and oversight in our Parliament today over matters of delegated legislation. We pass a bill, then we don't know what happens to what rules they write, what notifications they issue, under what regulations the law is implemented. I really feel, sir, this is a larger point beyond this bill, that we need to seriously look at requiring the government to actually explain their rules to us when we pass bills. Now, there are two very important points, sir, that I wish to add before I conclude. First is that the Supreme Court of India, which I'm citing a lot today because it's such an important issue, has passed a judgment in March of last year suggesting to the government to amend the Criminal Procedure Code to allow for trial in absentia. This is Hussain versus the Union of India, Piyush, if you want to look it up, 9th of March 2017. It's very similar. In fact, they actually alluded to Section 339B of the Bangladesh Criminal Procedure Code, because they said that will reduce the delay in trials when the accused absconds from the country. Now, even though the judgment was passed 1 year and 4 months ago, our government has shown no urgency in implementing the suggestion. If the government could bring in an amendment to this effect, then if fugitive economic offenders stay abroad, you can try them in absentia, and you'll have the Supreme Court's own backing for it. But the government hasn't had the courage to do this. Now, the other idea that they've got, that attaching the properties of absconders will force them to return, is laughable. One of the most prominent businessmen who fled the country a couple of years ago sold some of his estates before leaving the country. All the objectives of the bill can be easily bypassed by a fugitive economic offender if he sells off his property before it's attached. The government needs to undertake a comprehensive review instead of our extradition process. That is where the flaw is. I know that the previous speaker alluded to it. I have written extensively on this subject. The fact is that while we definitely need to ensure that there is better intelligence and those engaging in fraudulent activity can be nabbed before they leave the country, the fact is that when the previous speaker asks why we hadn't brought a fugitive economic offender law earlier, the fact is these are matters that are already within the capacity of the government to do. They can strengthen the CRPC. They can allow for trials in absentia. They can move. So extradition. I should say that in the UK, for example, we have put up so many extradition requests, but in the last 25 years, only one person has been extradited back to India. What's wrong with us, and why isn't the government fixing that? The fact is, you see, very much so, Mr. Deputy Chairman, we are essentially seeing an exercise in passing a hastily drafted legislation to play to the gallery while ignoring the real issues of the non-implementation of the laws, by ignoring the government's own failure to do the things that I have suggested, and then we are now essentially shutting the stable door after the horse is bolted.
Right.
Last point, sir, by putting forward a bill, many of the provisions of which will be struck down as unconstitutional, the government is only making a show of being tough on fugitive economic offenders. This is too serious an issue to become another Jumla. I urge the government to take another look at their bill and amend its provisions suitably. As Ghalib put it, since they are rather fond of Ghalib, let me say, nazar ko badlo to nazare badal jate hain, soch ko badlo to sitare badal jate hain, kashtiyan badalne ki zarurat nahi, disha ko badlo to kinare khud badal jate hain. Look at this bill again, sir. I urge the government. The Prime Minister has called himself the Pradhan Chowkidar. The Chowkidar seems to have been asleep at the gate. We are putting a heavy panel.
Honourable Deputy Speaker.